Write a short note on rules applicable to substance of dispute. Section 28 of the Arbitration and Conciliation Act 1996 provides rules which are applicable to the substance of disputes. It specifies the law or the rules of law according to which the arbitral tribunal shall decide the disputes submitted for arbitration. Section 28(1). In the case of the place of arbitration is India, Section 28 subsection 1 clause A of the Arbitration and Conciliation Act 1996 provides that the arbitral tribunal is to decide the dispute submitted in arbitration according to the substantive law for the time being in force in India. Substantive law implies the set of laws that defines the rights and responsibilities in civil law, crimes and punishment in criminal law. Section 28 subsection 1 clause B. In the case of international commercial arbitration, the tribunal shall decide the disputes in accordance with the rules of law designated by the parties as applicable to the substance of the dispute. Section 28 subsection 1 B2. If the parties have designated the law or legal systems of a given country, it is construed as referring directly to the substantive law of that country and not to its conflict of law rules unless otherwise expressed. Section 28 subsection 1 B2. If the parties have not designated any law, the arbitral tribunal shall apply the rules of law it considers to be appropriate given all the circumstances surrounding the dispute. These provisions ensure that the arbitral tribunal applies the correct substantive laws to the dispute, reflecting the parties' agreement, or in the absence of such agreement, the laws that the tribunal deems appropriate. This framework supports the autonomy of the parties in arbitration and the flexibility of the arbitral process. The Act lays down for the arbitral tribunal to decide according to the terms of contract and usages of the trade which are applicable to the transaction. Section 28 subsection 2. The arbitral tribunal can decide ex equo et bono according to what is fair and good or as amiable compositor according to the principles of equity. Only if the parties have expressly authorized it to do so. In the usual course of the process, the rules which the parties to the dispute designate are applicable to the substance of the dispute. The parties may also empower the arbitral tribunal to decide the cases in their good conscience without adhering or to any strict laws or rule of law. The ambit of the specification of rules which may be applicable to the substance of dispute is very wide, owing to the fact that the legislation uses the words law or rules of law, which include transnational laws or rules of international conventions, etc. Prior to the 2015 amendment, the powers of the tribunal to apply its own discretion were very limited, and it had to strictly abide by the ambit that the contract and usage of trade set for the parties. This made it difficult to render justice, as one of the parties was usually able to exploit the situation and make the other party sign such terms which went against the basic nature of opportunity or equal bargain power of both the parties. Section 28 subsection 3. While deciding and making an award, the arbitral tribunal must take into account the terms of the contract and trade usages applicable to the transaction. In case of international arbitration, where parties have designated the rules of law, in case of international arbitration, Section 28 states that the arbitral tribunal shall decide the dispute according to the rules of law that the parties have designated as applicable to the substance of the dispute. Due to the use of the term rule of law, the ambit of the law has been widened considerably. The parties are not restricted to the national substantive law. They may also choose transnational laws, international law, principles, or the rule of international law conventions. Most commonly used rules are lex mercatoria, which incorporates international commercial rules and general principles of law and is not based upon a specific legal system or the principles of the international commercial contract drawn up by UNCITRAL. The parties may also split the law applicable to the substance to several issues or empower the tribunal to render a direct decision based on reasonableness and fairness. But parties have not designated the rules of law. Party autonomy is a fundamental principle in international arbitration. An aspect of this principle is that the parties are free to choose the laws or rules of law which are applicable to the substance of the dispute. However, in case the parties do not expressly state which law governs to the substance of the dispute, the tribunal has the authority to apply the rules of law it considers appropriate given the circumstances. The tribunal has the power to deviate from any strict laws or rules of law and decide on the basis of its own good faith only in cases where the parties expressly authorize it to do so.